We are joined now by the star witness, Michael Cohen. Michael, thanks for coming back.
Good to see you, George.
GMA. You were here with us, sitting in that chair in March 2023. You predicted this outcome, so you're not surprised.
No, I'm not. In fact, next month, George, is when you and I sat down for that historic change in my life. That was July 1st of 2018, 6 years ago, when I turned around and I told you that my wife, my daughter, my son, and my country have my first loyalty. And this has been one heck of a journey in order to keep it.
One heck of a journey. How about that time in the courtroom? What was the toughest moment for you?
I really didn't have a single moment that was tougher than the 21 hours that they had me on the stand, whether it was on direct or on cross-examination. The whole thing was very tough. It's emotionally draining because you have to be perfect. I knew that any mistake that I made would be just, it would become the topic of conversation that would just explode. And so I really just needed to stay focused.
What's happening, people? Welcome to Jack Mockler again. A political earthquake is rumbling through the corridors of power, shaking the very foundations of what we thought we knew about justice, accountability, and the limits of presidential power. The words that have become the battle cry of a political movement, the shield behind which an entire defense strategy has been built, the mantra repeated at rallies, on social media, in every press release and every television appearance by allies desperate to protect their leader, have just been weaponized against them in a devastating judicial reversal that nobody saw coming. Those two little words, simple, dismissive, designed to undermine everything prosecutors have built, have now been turned on their head in a ruling that lands like a thunderclap across the legal and political landscape. The irony is so thick you could cut it with a gavel. What has unfolded in the federal courthouse represents one of the most politically devastating legal developments of the entire modern era, a ruling that dismantles the central narrative that has sustained a political movement through years of legal turmoil.
And it wasn't easy with Todd Blanche. He's a meanderer as it goes to questioning.
He called you the greatest liar of all time. You've been convicted for lying. Are you done lying?
Yeah, you know, I want people to also remember, I take responsibility for what I did. But remember that the lie, we have to remember what it was. It was the number of times that I claimed to have spoken to Donald about the failed Trump Tower Moscow project. I stated 3 versus 10. I shouldn't have done it, but I did it in coordination and at the direction of Donald, Jay Sekulow, Ivanka, Jared, Abilol, Ty Cobb. There was a whole group of people involved in the creation of that document. Now, I don't ignore my responsibility. I accepted it and in part went to prison for it. But I don't want people to think, you know, just because you lied about that, I didn't really think it was all that material, but I took responsibility for it.
And you're done now?
Absolutely done.
The phrase that Donald Trump has deployed more than any other to defend himself against the avalanche of legal problems surrounding him, the two words that have become the foundation of his entire defense strategy and the central argument he uses to convince his supporters that everything being done to him is a fraudulent political hit job, has been used against the very people who have been pushing that same narrative in court. No evidence. That is what Trump always says about the cases against him. No evidence. Total witch hunt. They have nothing. The whole thing is made up by people desperate to stop him. No evidence. And now a federal judge has used those exact same words in a written ruling that eviscerates the conspiracy theories that Trump's allies have been advancing in court. The judge, wearing the robes of impartial justice, examined a major case connected to Trump's inner circle, went through the arguments being made by his allies, evaluated the claims of political persecution, deep state manipulation, and weaponized prosecution.
Did you have any moments in the courtroom where you actually had some kind of contact, communication with Donald Trump?
Only once. The rest of the time, he had his eyes closed. He was slumped back, not sure whether he was sleeping or just resting his eyes, as he would say. But there was very limited interaction. Not to mention where you sit, it's very difficult to see the defendant the way that the judge's box versus the witness box to see the defendant, who's more to the right. I had a better view to the left of me of the jury than I did of Donald.
I'm just wondering what that was like for you. You spent years fighting for Donald Trump, bullying people for Donald Trump, even lying, as you just said, for Donald Trump in coordination with his people. Do you wish you'd never met him?
I do. This has been enormously difficult on my family more than anything. It's been hard on me, but as hard as it is on me, watching my family suffer.
And delivered a verdict on those claims that must have sent shockwaves through Trump's legal team. No evidence of interference, no evidence of a deep state conspiracy, no evidence that the Trump administration manipulated the prosecution, no evidence that any of the things Trump's allies were claiming were actually happening. A federal judge said it officially in a written ruling on the record, and it lands like a thunderclap because it did not land the way Trump's team expected it to. This was not a ruling dismissing charges against Trump himself. This was a ruling dismissing the conspiracy theories that have been used to protect him. The very arguments that have been deployed to paint every prosecution as a political hit job have been found legally insufficient by a federal judge applying real legal standards to actual claims. Now let us understand precisely what happened here, because the details matter enormously for the broader picture of Trump's legal situation.
As a direct result of my actions and the misloyalty that I gave to Donald, it's something that haunts me every day.
So how did you feel when you heard that first guilty?
I let out just a gasp of air. I camped 6 years. Remember the first time that I met with the District Attorney of New York's people, I was a prisoner in Otisville. I was in my greens. And they came back 2 more times after that. 3 times I met with DAs for New York while I was at Otisville. So this has been a long time coming for accountability.
As you know, there are a lot of Republican office holders out here, including the Speaker of the House, who are saying this is a disgrace. They're still backing Donald Trump. What's your message to Republican politicians and voters who are still considering voting for Donald Trump for president?
I'm not sure how it makes any sense. This is not just now a felon, convict, but it's also a man who has...
The case in question is the Brov 6 conspiracy case, a prosecution involving defendants aligned with or connected to the Trump political world. Their defense team had been pushing a narrative that has become painfully familiar in Trump-adjacent legal proceedings. The argument that the prosecution itself was politically motivated, that the government was weaponizing its prosecutorial power to target people connected to Trump, and that the Trump administration had somehow improperly interfered in the case to manufacture a prosecution that served political ends. This is a serious claim. If it were true, it would be the kind of thing that could get a case thrown out entirely and discredit the prosecution. And so the defendants filed motions pressing that argument, arguing that there was improper influence, that the process was tainted, that the deep state conspiracy theory applied to their specific case. And the federal judge looked at all of it. The judge went through the arguments, examined what evidence existed, and ruled no evidence. There is no evidence that the Trump administration improperly influenced or interfered in this prosecution. The motion was tossed. The conspiracy theory, at least in this case, did not survive legal scrutiny. Now here is why that ruling carries weight far beyond just this specific case. The broader narrative, the one Trump has been building for years about weaponized government, about deep state persecution, about prosecutors and judges working in coordination to destroy him for political reasons, that narrative depends on at least some of it being provable in court. It depends on judges finding at least occasionally that there is actual evidence of improper motivation behind the prosecutions. And what keeps happening instead is that judges look at the claims and say no evidence. Not we looked and found a little bit, now there are some concerns but not enough to dismiss, but no evidence. And every time a judge says that, the foundation of the victim narrative cracks a little more, because the victim narrative is not just a political argument, it is a legal argument. Trump's team has used it in actual courts to try to get actual charges dismissed, and actual judges keep evaluating it by legal standards and finding it does not hold up. This brings us to the heart of the matter, the gap between the legal reality Trump faces and the political narrative he has constructed to protect himself from that reality. At the exact same time that judges are throwing out conspiracy claims for lack of proof, the actual criminal cases against Trump are still very much alive. 88 criminal charges across 4 major cases, 34 counts in New York that have already produced a guilty verdict, more than 40 counts in the federal classified documents case, 4 federal counts tied to the effort to overturn the 2020 election, multiple state counts in Georgia under a racketeering indictment, 88 charges. And the cases that have gotten charges dismissed, they were not dismissed because prosecutors ran out of evidence. They were dismissed on technical legal grounds, drafting issues, procedural problems. The court evidence that put those cases together in the first place is still there. Grand jury testimony, documents, phone calls, text messages, recorded conversations, sworn statements from witnesses who were in the room. The evidence didn't go anywhere. Just some of the specific charges got trimmed on technical grounds, while the core of the prosecution stayed alive. This distinction between a technical dismissal and an exoneration is perhaps the most misunderstood aspect of Trump's legal situation, and his team has worked tirelessly to blur that line for public consumption. When a judge throws out specific counts because they were drafted too vaguely or because they don't fit the precise requirements of the applicable statute, that is not a finding that the defendant did nothing wrong. It is not a finding that there is no evidence. It is a finding that those specific charges as written cannot legally stand in their current form. The conduct they were trying to capture may still be criminal. The evidence that prompted those charges may still be in the record. The prosecutors may still be able to refile in a different form or proceed on the remaining counts or use that evidence in other ways. A technical dismissal is the legal equivalent of being told you filed the paperwork wrong, not the equivalent of being told you did nothing wrong. Trump's campaign to frame every technical dismissal as proof of vindication is one of the most sustained and successful pieces of political spin in recent memory. But in legal terms, it simply is not accurate. The evidence that supports the remaining charges is substantial and has been documented extensively throughout the investigative process. Grand jury testimony from witnesses who were in the room when critical decisions were made. Documentary evidence from financial records and business transactions. Electronic communications including emails, text messages, and phone records. Recorded conversations that capture key moments in the alleged schemes. Surveillance footage from locations where events relevant to the cases occurred. Financial records that document the flow of money through various entities and accounts. Sworn statements from witnesses who have testified under oath about what they saw and heard. This is not a situation where prosecutors built thin cases on circumstantial evidence and a prayer. These are cases that grand juries composed of ordinary citizens, not political operatives, found credible enough to indict on. Grand jury indictment means a group of ordinary people looked at the evidence and found probable cause to believe crimes were committed. That is a meaningful legal threshold, and Trump crossed it on 88 counts across 4 jurisdictions. The contrast could not be more stark. On one side, a federal judge ruling no evidence on the conspiracy theories Trump's allies are pushing. On the other side, prosecutors sitting on mountains of evidence that have already persuaded multiple grand juries to return indictments on 88 separate counts. The victim narrative, the deep state persecution story, the witch hunt framing, the everyone is out to get me because I'm fighting for you narrative. That narrative keeps getting undercut in real courtrooms by real judges applying real legal standards. And while that narrative is getting dismantled, the 88 charges are still sitting there, still being litigated, still representing real legal exposure that his team has been working overtime to delay and shrink and appeal and immunize away. The delay strategy has been the most effective tool in Trump's legal arsenal, but it is not a permanent solution to the problems he faces. The delay strategy has worked with remarkable effectiveness because it has exploited every available procedural mechanism in the legal system to push trial dates further into the future. Appeals filed on virtually every ruling, even those that clearly favor the prosecution, motions to dismiss on grounds that range from the plausible to the implausible, immunity arguments advanced to the Supreme Court, recusal fights against judges who have been assigned to cases, venue disputes, arguing that trials should be moved to more favorable locations. scheduling conflicts tied to his political activities that somehow always seem to require postponement of legal proceedings. Every tool available in the legal toolkit has been deployed to push trial dates further and further into the future. The Supreme Court's immunity ruling, which found that presidents have substantial immunity for official acts, was itself a delay mechanism, sending cases back to lower courts to determine which alleged conduct fell within or outside the scope of official presidential action. That process takes time. Every appeal takes time. Every referral to a lower court takes time. And time is the one resource Trump's strategy has consistently traded everything else for. But here is the reality that Trump's team does not want you to understand clearly. Delays are not permanent resolution. The cases that are still alive are still moving on whatever timeline the courts impose. The immunity questions that went to the Supreme Court came back with rulings that provided some protection for official acts but left significant questions about unofficial conduct, and lower courts are working through exactly where those lines are. That process is not infinite. At some point, and probably sooner than Trump's team would prefer, courts are going to run out of patience with further delay and set trial schedules that actually hold. And when that happens, when the cases that have been hanging in legal limbo for years actually go to trial, the evidence that prosecutors have been sitting on gets presented to juries. Regular people, citizens, not political operatives, not media commentators, not loyal supporters at rallies, jurors who take an oath and evaluate evidence according to legal standards. The New York case already went through that process. 34 counts, guilty verdict. That is the template for what happens when Trump's legal exposure actually gets in front of a jury. The civil fraud judgment in New York added another layer to the picture of documented misconduct, with a judge finding that Trump and the Trump Organization had massively inflated asset values to defraud lenders and insurers. The contempt findings, when Trump refused to comply with subpoenas in New York, demonstrated that even civil legal process had to force his compliance. None of that looks like a system that has no evidence. It looks like a system that has a great deal of evidence and is working through the legal process of dealing with it, and that evidence does not go away because the political situation changes. The charges do not disappear because the president gives a good speech. And that is why the legal picture is in some ways the most durable threat to Trump's long-term political standing, because it exists independently of the political wins. The legal pressure is not going away, because unlike polling numbers, unlike political narratives, unlike approval ratings that can shift with good news cycles, criminal charges are not moved by rallies or press releases or social media posts. The political implications of this legal situation are enormous and cannot be overstated. Trump is a sitting president with 88 criminal charges outstanding across multiple cases, with a guilty verdict already on the books in one case, with a massive civil fraud judgment against him in another, with a contempt record from refusing to comply with legal process, and with conspiracy theory defenses that keep failing to survive judicial scrutiny, and at the same time, his support is showing signs of strain. The political coalition that made his second turn possible is showing signs of stress. That is a lot of pressure hitting at the same time from a lot of different directions. The legal pressure is not going away because, unlike polling numbers, unlike political narratives, unlike approval ratings that can shift with good news cycles, criminal charges are not moved by rallies or press releases or social media posts. They move through courts on legal timelines according to evidentiary standards that do not care about who is popular or who controls the White House. The gap between Trump's version of his legal situation and the actual legal situation is enormous, and it is getting wider every time a judge puts something in writing. The rulings keep coming down, and they keep telling a consistent story. The conspiracy theories about weaponized prosecutions are not surviving judicial scrutiny. The actual prosecutions keep moving forward with their evidence intact. The technical dismissals that Trump celebrates are not the exonerations he pretends they are. And the delay strategy, for all its tactical effectiveness, is not a permanent solution to the legal problems Trump faces. At some point, the cases will go to trial, the evidence will be presented to juries, and the legal system will reach its conclusions. Those conclusions will not be determined by political pressure or public opinion or the size of the crowds at rallies. They will be determined by the evidence, the law, and the impartial judgment of juries who take their oaths seriously. The evidence that supports the remaining charges is substantial and has been documented extensively throughout the investigative process. Grand jury testimony from witnesses who were in the room when critical decisions were made, documentary evidence from financial records and business transactions, electronic communications including emails, text messages, and phone records, recorded conversations that capture key moments in the alleged schemes, surveillance footage from locations where events relevant to the cases occurred, financial records that document the flow of money through various entities and accounts, sworn statements from witnesses who have testified under oath about what they saw and heard. This is not a situation where prosecutors built thin cases on circumstantial evidence and a prayer. These are cases that grand juries composed of ordinary citizens, not political operatives, found credible enough to indict on. Grand jury indictment means a group of ordinary people looked at the evidence and found probable cause to believe crimes were committed. That is a meaningful legal threshold, and Trump crossed it on 88 counts across 4 jurisdictions. The legal picture that emerges when you strip away the spin and just look at what the courts have said and what the evidence shows is remarkably clear. The conspiracy theories are failing in court. The evidence is substantial and well documented. The technical dismissals are not exonerations, the delay strategy is not a permanent solution, and the cases keep moving forward, albeit slowly, toward their eventual resolution. That resolution will come in courtrooms, not on social media. It will be determined by evidence, not by rhetoric, and it will have consequences that no amount of political spin can change. Trump's fears about prison are not baseless because the legal exposure he faces is real and substantial. But the path from those charges to any potential sentence is long and uncertain, filled with procedural obstacles and legal challenges that his team will continue to exploit to the fullest extent possible. The question that sits at the center of all of this is how much longer the delays can hold. The rulings keep coming down, and they keep telling a consistent story. The conspiracy theories about weaponized prosecutions are not surviving judicial scrutiny. The actual prosecutions keep moving forward with their evidence intact. The technical dismissals that Trump celebrates are not the exonerations he pretends they are, and the delay strategy, for all its tactical effectiveness, is not a permanent solution to the legal problems Trump faces. At some point, the cases will go to trial, the evidence will be presented to juries, and the legal system will reach its conclusions. Those conclusions will not be determined by political pressure or public opinion or the size of the crowds at rallies. They will be determined by the evidence, the law, and the impartial judgment of juries who take their oaths seriously. The evidence does not change because the political situation changes. The charges do not disappear because the president gives a good speech. And that is why the legal picture is in some ways the most durable threat to Trump's long-term political standing, because it exists independently of the political wins. The broader implications of this situation extend far beyond Trump himself. The integrity of the American legal system is being tested in ways that it has not been tested in generations. The ability of courts to function independently of political pressure, the willingness of prosecutors to pursue cases against powerful figures, the capacity of juries to render impartial verdicts in politically charged cases, all of these are being put to the test. The rulings that have been coming down from federal judges have been a credit to the system, applying legal standards consistently regardless of the political implications. The no evidence ruling in the Brav 6 case was a straightforward application of legal standards to the claims being made by the defendants. The judge looked at the evidence, found it lacking, and said so. That is how the system is supposed to work. Evidence matters, legal standards matter, the truth matters, and no amount of political spin can change that fundamental reality. Trump's legal team has been extraordinarily effective at one specific thing: slowing everything down. Appeals, motions to dismiss, immunity arguments, recusal fights, venue disputes, scheduling conflicts tied to his political activities. Every tool available in the legal toolkit has been deployed to push trial dates further and further into the future. The Supreme Court's immunity ruling, which found that presidents have substantial immunity for official acts, was itself a delay mechanism. sending cases back to lower courts to determine which alleged conduct fell within or outside the scope of official presidential action. That process takes time. Every appeal takes time. Every referral to a lower court takes time. And time is the one resource Trump's strategy has consistently traded everything else for. Every month without a trial is a month without a verdict. And every month without a verdict is a month where Trump can continue to control the narrative and tell his base that the cases are falling apart, that the evidence is thin, that the whole thing is a witch hunt. But the evidence is not thin. The cases are not falling apart. The delays are working tactically without changing what is actually in the record, and the question of how long those delays can continue is one that the courts are increasingly working to answer. Not on Trump's timeline, but on the legal system's own schedule. Stay tuned, because the next chapter in Trump's legal story, whichever case moves next, whichever court sets the next hearing, is coming regardless of what is happening politically. And when it arrives, it is going to matter. The legal exposure is real, the evidence is substantial, and the consequences could be severe. The courts are working through these cases on their own timelines, applying legal standards that do not care about politics or popularity or public opinion. The rulings will keep coming down, the cases will keep moving forward, and at some point, the juries will have their say. What they decide will reshape the American political landscape in ways that we cannot yet fully anticipate. But one thing is certain: the gap between Trump's version of his legal situation and the actual legal situation is enormous, and it is getting wider every time a judge puts something in writing.